I would like to dedicate this modest contribution to the memory of my beloved cousin Elena. Dear ladies and gentlemen, the matter of artificial intelligence seems to be all over the place. In order to offer a necessary normative framework to ensure that AI benefits like the improvement of healthcare, matters of manufacturing, and of sustainable energy could be enjoyed in a sensible and reasonable way, the European Commission proposed in April 2021 a regulatory framework for AI, emphasizing that AI systems have to be assessed according to the risk they could include. Whereas, of course, the whole matter of artificial intelligence can be seen as a dream of mankind coming true, or as Paulo Coelho would have remarked, o mundo está nas mãos daqueles que têm a coragem de sonhar e correr o risco de viver seus sonhos, meaning that the world is in the hand of those who have the courage to dream and take the risk of living their dreams. On the other hand, Karl Kraus would have remarked in one of his works, sie greifen in unseren Traum, als ob's unsere Tasche wäre. They put their hands into our dream as if it were our bag. So who, at the end of the day, puts his hands in our dream, in the dream of making artificial intelligence true? Legislator does, which is of course necessary, and in our situation here, regarding this modest contribution, we're talking about the European Union legislator. On June 14th of this year, 2023, the European Parliament adopted its negotiation position on the AI Act as proposed by the Commission, as I mentioned before. That initiated the talks with the Council in order to finalize the secondary legal act, and it remains to be seen what the outcome of these talks is going to be. As I said, the Commission proposal of April 2021 emphasized that the AI systems would have to be assessed accordingly to the risk they could include. And this risk assessment, which has to be a priori, a posteriori, and also on a constant basis in between, which one can imagine is a very difficult task to be done. This risk assessment shall be done on various levels, 3. The first one would be the unacceptable risk, where AI systems can be considered a threat to people, leading them to, at the end of the day, being banned. Social scoring, it is the potential classification of people based on personal characteristics, would fall under this category. Secondly, the so-called high risk, where AI systems could potentially negatively affect people's safety or fundamental rights. We would have to distinguish here between two different situations. On the one hand, AI systems in products falling under the European Union's product safety legislation and the Directive 2001/95 of the Parliament and the Council on general product safety would have to be mentioned here. On the other hand, matters of 8 specific areas that will have to be registered in an EU database dealing with biometric identification of natural persons, education and employment issues, as well as the ever-sensitive task of dealing with migration, operation of critical infrastructure, matters of public services and benefits, and the matter of law enforcement and interpretation. Thirdly, the so-called limited risk, which includes AI systems allowing their respective users to make informed decisions, including systems generating audio or video content. So the ball here would be pretty much in the field of the consumers. Of a highly practical importance would be the matter of generative AI, like ChatGPT. For those, the revised legislative framework of the European Union foresees that they would have to comply with the highest possible transparency requirements. It is, among other issues, to make sure and clear to consumers that any relevant content was generated by AI and is not illegal. As I said, it remains to be seen what the outcome of the talks between the European Parliament and the Council will be. Surely the dream of making artificial intelligence a part of everyday's life will need a legislative framework. Thank you very much.